Welcome from Operation Final Salute. And we've got a real privilege today. Our guest speaker is Judge Oscar Kazen, County Probate Court number 1. Obviously, the subject we're speaking on is probate. I have a definition of probate, but we're going to get a better one firsthand from our guest speaker. Judge, welcome. Thank you so much for presenting.
Thank you, Robert. It's my pleasure to be here. I often make the same joke. You can see by some of the stuff on the back of my wall. I'm not as lean and I'm not as mean, but I'm still a Marine. So, Semper Fi to all my brothers that are out there and their family members, as well as the all the other services that are so near and dear to my heart. Anything I can do to help out. Let me give you all a phone number. Now, remember, we can't give legal advice here, but you can always call a probate court for at least some direction. Our number here is area code 210-335-2190. Feel free to call us. I have been fortunate enough to have been wearing this robe for over 20 years now. And the robe that I wear, I tell everybody the same thing. It's a robe. It's not a crown. I'm here to serve you. Through that time, I've been a criminal court judge and on, and family law and a master and mental health. But probate is near and dear to me. No one ever does anything to deserve to be in probate. You're here because something happened to you and your family. And so we have a different feel. You come in here, you and your family, whether you've passed or they need us, will be treated with courtesy and respect. We will try to help them through the process as best we can. Sometimes probate can get a little sticky, and we'll talk about how to avoid those things. Sometimes it can get a little emotional, and we'll talk about how we can get past that in a bit. But I think my first goal is to talk to you about what probate is. Robert, do you think I should just go ahead and proceed?
Yes, by all means. That's the logical place to start.
All right. So, it just kind of makes sense that when you pass, when you live and you pass, everything that you had with you, everything in the closet, everything in the U-Haul, everything you accommodated in life comes along with you. It still keeps going. You may not be around, but that U-Haul is still driving down the road without a driver. And something has to happen with your material possessions. What do we do with your property, with your gifts, with the things that you have often taken for granted and someone may find valuable? How do you distribute those assets? And honestly, the best way to do that is with a will. In Texas, when somebody passes away, you either pass away with a will or without a will. Now, let me answer a question right up front. Not everything, not every estate, not every person has to go through probate. Probate is the process that you use to ensure that things are given to people that you direct, and that the title to that stuff, the stuff you own, the thing that makes you own it, the title to your property, the title to your vehicle, that the title passes to either your next of kin by blood, if you don't have heirs, forgive me, if you don't have a will, or with a will to whoever you want to give it. So probate is the process of ensuring that there is a legal format for you to pass along title, ownership to the things that you've collected in life. You don't always have to. So for example, let's assume that someone passes away. They've got a bank account, they live in an apartment, they have nothing but small personal assets that no one is fighting over. There's really not a need to go through a probate court. Those things are often given amicably between family members. But when you have title to something, when you own a house and it's got mom's name and dad was a Marine, and mom passed away some time ago, dad was living in the house, he finally passed, but he's got 3 kids. How do we know where that property should go? Well, first, you want to look to see if he's got a will. Since he's a veteran, you also want to see if you can find his DD 214. That DD 214 is going to tell you, and you want to look for it, whether he was honorably discharged. Because if he was honorably discharged, he has the right to be buried in a military cemetery. And if he was a lifer, what we called lifers in the old days,
Mm.
it might even be paid for by the government. Not everyone is entitled to a free funeral, but they're entitled to be buried with honors as an honorably discharged veteran. So look for that will, look for that DD 214. If you don't know if he's got a will, wherever he lived, you can check with the county clerk. That county clerk has a register of wills. For example, if I had a will and I just want to make sure it's safe, I can march right down to the county clerk's office and I can pay my $5 and I can file my will there and it'll be kept there for life. And I can list who it is that can take the will out upon my death. So it's a good place to secure a will, but it's also a good place to look to see if there isn't a will. Once you get that will, you open it up and it'll tell you who it is that they wish to be the executor. And now you will have to seek probate. Sadly, in Texas, if you're going to go through a full probate, you do need to hire an attorney. You should have an attorney to present the case to the court. That'll include coming in with the will, reading it through, making sure that it's properly done, sending out notices to all the people who are interested or heirs. And mind you, in a probate, the people we're looking for are heirs, the ones who get something, beneficiaries, someone who's listed to get something, designees. I hereby designate that $10,000 should go to the SPCA, or creditors, people who want to get paid. So you go through the probate process. The probate process notifies all those people. They get a forum to come in and argue or agree as to who gets what, and we follow the will. If you don't have a will, then the probate process gets a little more complicated. It still works, but without a written will, and I advise you to seek, and by the way, the Texas Veterans organizations do offer a lot of advice and forums as to how to fill out wills. But if you don't have a will, then when you pass away, the court will ask two questions. Okay, what are we going to do with all this stuff, with his house, with his car, with his bank accounts? Well, they're going to ask first, who gets what? That kind of makes sense. Who are the heirs? Who gets what? And then they're going to ask, secondly, who gives what? Who's going to be the administrator? In Texas, who gets what is almost always followed by blood. It goes to the nearest relative and then out. Once that happens, once we figure out, and mind you, the court's going to hire a lawyer. Typically around here, in San Antonio, they're $600 to $750 part of the costs. A lawyer is going to go out and research and make sure that they know who all the brothers, sisters, cousins, who are the actual heirs that are going to get anything. They're going to report to the court. Then you're going to show up with your attorney, and your attorney's going to present the evidence, and we're going to determine who gets what. And then we're going to determine who gives what. Usually that's a family member or a friend or an interested person. Sometimes, sadly, it's a creditor, somebody who wants to get paid. And since they never got paid, they have to ask the court to get paid. And they come in as the interested person. But their goal is to get paid, not to make sure you're taken care of. So it's always a wise idea that if someone passes away, look for a will. You don't see a will, look for the DD 214, and then go seek the services of an attorney so you can administer their assets. Remember, if there aren't any assets to administer, you don't always have to go through probate. How are some of the ways that you can get to the point that you've passed on and you don't have to subject your family through probate? Well, most people towards the end of their lives have the luxury of disposing of a lot of their stuff. So as we get older, you start to look in the garage and you realize, I really don't need all that junk. Let me give it away. Let me sell it. Let me have a garage sale. Let me call my son and say, you know what? That lawnmower that I've been keeping since 1962 that I never ran, you should have it. And then my son will promptly take it to the landfill. But you can give your stuff away properly while you are alive. Additionally, there are some additional tools in Texas that you can use. One is called a transfer on death deed. The other is called a ladybird deed. They're about the same thing, But in essence, one gives you a little more benefit in being able to change your mind. But in essence, what they are documents that say, when I die, uh, this belongs to my son, and I live here till I die. And when I die, my son gets it, or my daughter gets it, or depending on the instrument, so and so and so and so split it. Yeah, you do have to be careful with transfer on death deeds and ladybird deeds because, you put someone in there 20 years ago and all of a sudden they're not your friend anymore. They still get it unless you've changed it. So you want to make sure that both the transfer on death deeds and the ladybird deeds are up to date. Review them every once in a while, as well as your will. Uh, I want to give my lawnmower to my next door neighbor, and I put it in my will. 10 years later, my next door neighbor and I argued over how to cook a steak, and I don't want to let him have my lawnmower anymore. Well, guess what? The will controls. So one of the last things to talk about generally about probate is as well avoiding probate by using instruments. So how many of us have ever opened up a bank account? Pretty much all of us. How many of us have bothered to actually read the document that comes along with your savings account or your checking account? There is a survivorship clause in every document that says, if I should die, then so and so is the survivor. They get to keep what's left in this bank account. That is a done deal, by the way, but that takes it out of probate. It now becomes a contract. Whatever you put in that survivorship clause is going to be what we execute, so that that family member or that friend or that designee gets what's in that account. As well, as we get older, we may want to consider what are called joint bank accounts, where you give with rights of survivorship, where your son is or your daughter is a joint owner to the account, even though you're the managing partner or person in the bank account. It gives them the right upon your death to basically take over that account. But again, beware, without a will, they're going to follow the instrument exactly. So, son, when I pass away, I want to make sure that you give half the garage and all the junk in my big chest, half to my sister, the other half to your sister, and a third to our next door neighbor. Okay? Um, unless it's written down, it didn't happen. Unless you got a will, it doesn't mean anything. There's a commercial where some guy is sitting on a park bench with his son looking out at a pond. And he says, someday when I die, this pond on our land will be yours. And then some guy jumps out of the pond and says, doesn't count, because it doesn't. Unless it's written, unless it's in an instrument, and unless it's in a will. If you die without a will and you have any property that needs to be transferred, it's going to be transferred by administration, and that's going to go by blood. So honestly, the will is your last remaining kind of say in this world. But as anything, how we say things matters more sometimes than what we say. And you'd be surprised as in the end, when someone passes away, the one thing that tears me apart as a judge, especially a probate judge, is if your kids were fighting when they were 12, they're still fighting when they're 60. The only difference is they can afford lawyers. And you want to avoid that. Just every single emotion, every single argument. You weren't really there for mom. I took care of her when you weren't. I paid for the roof. You didn't. You weren't there when you were 18. You left to California. You remember that? All those things come flooding back, and it's up to the veteran, especially the senior veteran, to be sure that they understand that their word is going to be a trigger. Their will is going to trigger emotions as well as deeds. Um, some of the things you can do is engage in estate planning. Engage the family that you're going to uh, dispose of property within the will in conversation. Let them know this is what I'm doing. Here's why I'm doing it. Let them understand that no one's coerced you or forced you or influenced you to do that. Talk to them about how you want your final word to be honored. I think that goes a long way to healing a family. Um, in the end, it is an emotional thing. remember, for as much as we think, we're gone from this world, we aren't in their hearts and we aren't in their minds. And our loss hits them harder than we can possibly imagine. So preparing for your death with proper estate planning, I haven't even talked about setting up a trust. You can talk to an attorney about that. But proper estate planning, set up a good will, talk to your family about how you want your end of life and your material things to be distributed. The more you do that, the greater the gift to the people you love when you pass on to the next world. Those are my
Super.
thoughts on probate.
That is super. I just want to tell the audience that this discussion is going to continue, but for Operation Final Salute, that's the end of this portion. All right. So, Judge, we're going to transition. Yeah, you gave us what is probably the 60-second waltz in 30 seconds.
Can I
So
can I share a story if I've got time?
please do. And now we're going into the second part. So you
I
have
wanted
read
you.
as me.
I wish you could have kept this in the first part, but I'll leave that
Well,
up.
and Sharon can choose to. And we
Good. I will leave that up to you. So uh, just a story that I share with everyone that comes through my court, especially if it's a family that's arguing in the end, and it happens a lot more than we thought. Um, when I was a young man, I suffered some loss, and my grandfather, I remember him, wise guy, gray hair, gray beard like me now, uh, walked me around the backyard, and I remember him telling me, he says, um, the Native Americans, the Indians, have a tale, and they have a belief that when we are born, a star lends its light to our spirit so that when we walk the earth, we can shine. And then he says, but the story goes on. When we pass from this earth, our spirit wanders back into the heavens to give the star its light back so that it can shine and guide the people we leave behind. And as old as I get, and through the years, when someone dies through probate, even in my own life, on a bright, starry night, I will look up, pick a star, and say hello to someone I loved and lost. I guess the moral of that story is they're only as far away as your heart lets them be. So don't let the legal process and probate eat you up, because in the end, they are still there, and you can still talk to them, and their light will guide you.
super. Nice story. Um, so as I said, we kind of got the very quick thumbnail. Can you tell us a little more about probate? Go a little bit deeper in the process and the kinds of things you see from the bench.
Sure. Um, you know, I think one of the things that often happens in probate that really hurts the probate process, it's the simple and fundamental uh, need to save money. Okay, people never want to spend the money that they have to spend on the things they truly need, and a will is something you need. And I've had people who try to do what's called a holographic will. That certainly can work. You can certainly write out, get on the internet and research what a holographic will is. And as long as it's all written in your handwriting and signed by you, then that will operate almost the same way. You still have to get some witnesses at the end to say that that was your handwriting and etc. But but what have you really saved? If anything goes wrong with that will, you might have saved yourself a few pennies, but you just destined the people you have left behind with all the cost and expense of an invalid will. Or if you take a shortcut and don't go talk to an attorney or don't plan your estate. Um, the one thing I see more often than not are the children suffering through added expense because dad or mom took a shortcut. They were trying to save a penny here and a penny there. And what they did was cost their children. And what's funny is if I sat down any veteran and looked them in the eye and said, man, would you jump in front of that bullet to save your kid? Most of them, pretty sure all of them, would say yeah, but then they go try to save $100 or $200 by trying to do this, or $1,000 by trying to do it the cheap way. You'll take a bullet, but you won't spend an extra grand if you have to. I guarantee you that in the end, uh, what you do in life by way of probate, getting a good will, talking to an attorney, making sure people know where the will is, uh, will be the greatest gift that you can give your children or your loved ones in death. So that would be the first thing that I see, that people trying to save money and losing it. The other thing I see is waiting. So many times you actually do have family members that get along, almost always, fortunately. But they get along, and the mom and dad's estate is not too big. I mean, when my mom and dad passed, they both had wills, but my sisters and I got together and we divided up all the, the things that were important to us, and then we had an estate sale, and that money went into the estate account, and then we divided it up just like the will said. So it was pretty amicable, right? But what often happens is that someone's living in a house that mom owns or dad owns. And one of the brothers decides, well, I really don't want to kick my sister out of the house that she's been living in. You have to remember, in Texas, you only have 4 years to probate a will. If you don't probate the will, you have genuinely complicated matters. And in some cases, actually invalidated the entire will, depending on the circumstance. All right. So you've got 4 years from the date of death to probate a will before you have to jump through a whole bunch of extra hoops. What often happens, especially in San Antonio, and I'm going to speak to the demographics of San Antonio, okay? We have some neighborhoods from, where the socioeconomic level and their ability to actually hire an attorney or have a lawyer on their cell phone, it just doesn't happen. So you've got a house, and as in my family, I've got some cousins. They've got a house and they live there, and grandma lived there. And when she passed, my aunt Tia lived there, and her kids lived there. And then when she passed, Mijo lived there. Well, what happened along the way is that the title never transferred to that property, right? And now you've got some serious issues. Not only does Mijo now have to decide what to do with the property when all the other kids want some piece of it, but mom never owned it and grandma never passed it. So we've got 3 generations or 4 generations all arguing over property that more than likely has never qualified for a loan, never been able to be improved, and can't be sold. And think about that for a second. In our neighborhoods, what is the truest sense of passing wealth? It's the house we live in. We pour our blood and our soul and our money into our houses to fix them up and live there and get equity. And then that equity is passed on to the next generation so that they can lead and live a better life. And then that equity is grown into a bigger or nicer or even improving that premises. But when you don't have a way to pass that equity on, it's as if you've got 10 gold bars buried in the backyard and you don't know where. You'll never touch it. So, having a deed lets you transfer title, having a transfer on death, having a ladybird, having those things resolved. So here's one. I'm talking about your will. What about your mom and dad's? They passed before you, the grandparents of these kids, of your kids. What about their property? Did you ever transfer their property? Is the house you're living in transferred to you so that you can transfer it to your kids one day? Those are all the considerations you need to look at. And Mr. Kozel, Robert, it is exactly part of when you ask me what are some of the complications. That is the complication. Oh, we're ready to probate mom's estate. Well, what do you mean it's grandma's property? Yeah, nope, she never transferred it. Oh, what do you mean the deed is in grandma and grandpa's name who died in 1975? You know, it makes it difficult. So you want to make sure that you're up on that and you take care of that. So don't wait too long. You've only got 4 years. Try to be as amicable as you can. The other thing I see, and it's a difficult choice to make, is Invariably, as I said earlier, if your kids were fighting when they were 12, they're still fighting when they're 60. Only difference is they can afford lawyers, right?
Sure.
If you sense that there's that level, some level of consternation, some level of, they're kind of angry with each other, they got some issues. Yeah, your kids have been fighting. You may want to consider an executor who's detached, someone who isn't getting anything from the estate. You can, in certain instances, you can actually give them a percentage or some money as part of the will, compensation for their service as an executor, but take it out of the family, put it in writing, and get a neutral third party who agrees to make sure you let them know you did it, agrees to be your executor, agrees to administer these things. That saves a lot of hassle. At least the kids aren't tearing each other up, and there's something to be said about that in the afterlife. So those are kind of the juncture of issues that I see, the very fundamental emotions that make the probate court process difficult. Um, the actual process, more specifically, it's a pretty straightforward matter. We have an estates code. In fact, if you ever Googled what are the steps to probate my mom's will, you would be surprised. There is a it'll always pop up, a perfectly good, even on just a general Google search, perfectly good lists. First, get the will. Second, find an attorney. Third, file an application to probate the will. You file it with the court. You pay the court costs. You go and tender it. They keep the will in the application. Next, work with the court to get a court date. Then the court will give you, in our court, the way we do it is we give the lawyer a checklist. It says, here, these are all the things you've got to do. The notices you've got to give, the people you've got to inform, um, the applications that need to be filed, the postings. These are all the things you have to do. Oh, and by the way, if you do it right, you can probably do it in about 30 days. Okay. If you do it right. And the lawyer gets it and checks off the box and does everything and does their notices and files the application. And if nobody contests the executorship, if there's nothing wrong with the will, um, as soon as the lawyer calls our court and says, our checklist is done, Judge, we're ready, I can have you before me within 5 to 10 days.
Hmm.
That's how quick. So I hear all the time, probate takes so long. The courts are taking forever. It's really not the courts. I mean, we're here every day. As soon as the lawyers check off the check boxes, do what the statute requires, we'll give you a setting. Some courts are a little quicker on that setting than others. Mine's within about a week, 10 days, and you'll be in front of me. If it's taking a long time, what people often forget and what they don't explain is there's something wrong with the will. There's the families fighting with each other. Someone's putting up roadblocks, or they don't want to sign waivers, et cetera. They don't want to accept the service. They're angry with the brother, and no way in heck are they going to cooperate. You know, um, she was never around. She left when she was 18. I had to take care of mom. Why do I need to tell her or give her anything? That's usually what delays the probate process. That and sometimes we run into the odd circumstance of, hey, there's a whole nother family somewhere else. There are issues. Yeah, there are issues. The reason I went, yeah, is because I'm looking at them on the screen and they all went, ooh. Yeah, there's family somewhere else, or there are incredible debts where you have to give this notice in the process where you put out this, you know, but if there are, you put out this notice that requires creditors within a certain period. That's also a reason it takes a little longer. But to put out this notice that says, okay, to all creditors, now's your chance. You better let us know what we owe you, or else after so many days, we're not going to pay you. Um, so that goes out. And occasionally we get creditors who are owed quite a bit of money who really want to come in and go after their assets, or something else that delays a probate rather than it be quick, and that is they're trying to foreclose on the house. The house that is going to be passed is behind 6 months worth of payment, and the bank wants it, and they want their money before it goes anywhere. So that tends to delay the probate of a case. Now, this is important. When I say you can get a probate within 30 days, that doesn't mean it's closed. That means that I can issue with 30 to 45 days, I can issue your letters testamentary that says, okay, you did everything you're supposed to do. Here's your paperwork. Go do what you got to do. Sell the house, split up the profits. You have 2 years from the date that I hand you that letter that says, okay, you've done what you need to do. Go probate your dad's estate. Go take care of your family. Whoever the executor is, here's your letter. It's called letters testamentary. Um, they've got 2 years from the minute I hand it to them to make sure, and they qualify, by the way, to make sure that they've administered the estate. So that is the fourth problem that we run into. And that is an executor who just kind of lollygags around past the 2 years. You've got 4 years to get it probated, and then you've got 2 years to get it done. All right. The inner part really shouldn't take that long unless for some reason, um, except that's my other judge, I'm letting him in. Unless for some reason they run into problems. So just remember those numbers. You've got 4 years to get a probate done, get it probated. Please don't take 4 years. And you've got 2 years for the executor to administer the probate. And after the 2 years, then you're probably coming back to the court to fight over why it hasn't happened. So I hope that answered
Judge,
your question.
it does, but I have a question for you. I'm fortunate to hear someone like you speak, and I shake my wife and say, we've got to get on this, and we do, and things look good, and our lawyer was a good one, but one of us dies. What happens? Am I in reset mode? I talk like I'm going first. My wife would be giggling in the background. But where am I when one partner dies as far as the process? What do I need to do?
Well, again, if you've got, so in your case, you've got two seniors, maybe a veteran who's fortunate enough to be able to go to some of the veteran services and the VAs for guidance. But if the first question is, do each of you have a will?
I'm assuming we do.
Okay, then you open the will, you look to see who the executor is, you go speak to an attorney if it is you, and then you file for the application of probate of the will. And you follow the checklist. After the checklist is done, the notices, the postings, and the application, you get a court date. And then you'll get ultimately a letter testamentary that allows you, let's presume that you've got one of those wills where you're the executor and you're in the event of your wife's death, and she's the executrix in the event of your death, then you will each be given a letter of a testamentary. It's, oh, it's hanging on the right there. Sorry about that,
Do,
guys.
do I then have to reset my will? Because chances are I named my wife and then our
You should
son.
you
Yeah,
can you should update it. Typically, you want to look to the will. Um, the will itself, typically, if it's done right, does alternatives. Everything to
okay.
me, everything to my wife in the event of my death. In the event my wife should have predeceased me, then to X, Y, and Z, my three favorite letters. You know, and in the event my executor is not able or does not qualify as an executor, then my alternate executor is so and so. All right, it's called a successor executor. Most wills are written in that capacity. Again, that's thank you for asking that question because it answers, it's a callback to an earlier conversation. And that is, and that's where we get in trouble, where you try to save money by not doing a good will and having a lawyer vet it, right? Yeah, you get a will off the internet that doesn't include kind of the alternate language and is it really looked at to make sure that you're protected? And lo and behold, now you've just given your kids a whole bunch of headache or yourself, right? So you should update your will. Typically, that's the best practice. But typically, as a practical matter, many of these wills are written with "in the event of," and may at least get you past the current circumstance.
Okay. You mentioned
Plus,
family.
plus I got to tell you, if your wife does pass, it's always a good opportunity for you to review your wishes. Remember, you wrote that will in a different state of mind, you and your wife together. You might have written it when you were 40, right? Or 50, or
Sure.
60, or 70. But the whole point is you wrote it some time ago. You may not be in that same space emotionally or practicably, and you should review your will anyway, sit down with your wife and think about what you want and whether you want to change it. You should, as I said, discuss it with your family. Talk to the people about why you're doing it and how you're doing it. At the very least, it leaves a trail that when you did it fully competent, and that nobody, you've got witnesses. I talked to them. Yeah, Dad talked to me. He told me why he wanted to do that. Not, Dad couldn't even remember his name. I don't know how he signed the will. All right.
Even if I think I'm well prepared and get a good lawyer, try to do everything on my mental checklist to be prepared, are there stumbling blocks that people encounter that, oops, things have changed? I never thought about that, or things that come up that are just seem unforeseen, even though people should have caught.
You know, what often happens that is unforeseen is you've got more property to dispose of that you, especially when it comes to what are called specific bequests. I want my grandfather's gold watch. I want to give to my firstborn. Uh, the watch they gave me when I retired from the teachers union, I wanted to go to my daughter, who's a teacher. You know, those are specific bequests. Along the way, well, we get things. Our state grows, right? And inevitably, what winds up happening is if you don't take the time to change your will, those will just then be sold or distributed in portions according to the will. That 50-50 kind of clause. So one of the things you really want to do, one of the things that you will run into, I hate to say you will run into it because you've already passed, but one of the things your estate will run into is that if you don't periodically review the will to update it, some of the stuff you got between now and then just won't get passed the way you want it to, right? Additionally, there are some very genuine emotional circumstances. Um, Sometimes in Texas, uh, let me go backwards. In Texas, just because you're a child doesn't mean you have to be included in the will. Kind of, when we have a jury trial, that's one of the first questions when they're challenging wills that they ask a jury. Do you believe that children should get an equal share or a share of their parents' property upon death? And they'll say yes. And then they'll say, well, even if it's not in the will, and that's the one that gets it, well yeah, they're the kids. No. If I tomorrow wanted to write a will that gave everything to um, the the judge's education fund, uh, everything I own except for my community property, my wife, my children, no one could stop me. You are entitled to dispose of your assets in any way you wish. Now, going back to your question, sadly, we are human souls. Where we are now, emotionally, physically, is not and often will not be where we will be in the future. And man, sometimes you do have that kid that you just, enough is enough. Um, that especially happens with children who are mentally ill and have really, had a long history with their parents, and the parents just either have to make the tough choices of, well, I'm not going to leave him $100,000. He'll go kill himself. Um, and they have to make the tough choice of putting the money somewhere to be managed for him, or maybe not even passing assets to him at all. Or there is some emotional circumstance where people have just emotionally divorced. And, you know, even as it happens to our kids. And sometimes if you haven't updated your will, then those wishes, no matter how horrible they may seem, will not be followed, or vice versa. You've made amends. It's that classic story of the father who left and the son who hates him, and they just never got along. And but towards the end, they made amends. Towards the end, they looked in each other's souls and they saw each other as father and son. But the will never reflects that. What's in the will is in the will, and if it's valid, that's what will be followed. If it's not written and it's not valid, just like that commercial, it doesn't count.
Any additional thoughts?
Uh, yeah, this it has to do just generally with people going through probate. Seek to your higher calling. When mom and dad pass, and if you all begin to fight, ask yourself, is that really what mom and dad wanted? Is that the best way to honor your parents? And I know the emotions are hot and I know they're flaming, but especially when we're fighting over assets, when is enough enough?
Hmm.
You know, what is the true value of peace and love between siblings versus I got the boat and you got the truck? You know, what what's the value of that in the end? Because I guarantee you, at some point, just as you stood over your father, who was a veteran in that flag draped coffin, thinking about how much you loved him, and wishing you had just one more day with him, at some point you will be in that coffin, or the sibling that you so argue with right now will be in that coffin. And you know what? It's too late. So, just a thought. It's not really about probate, it's more about our humanity. Seek to your higher calling, seek to be human, walk lightly on this earth, and understand that, you know, some things are more important than winning, and some things are more important than money.
What a better place this would be.
Yep.
Sharon, anything to add?
Not at all. That was perfect.
Okay, guys. I'm
Uh,
always here for you. Call me, even email